Today's discussion topic another murder case with circumstantial evidence and how to prefer circumstantial evidence or how circumstance evidence can be proved with the case and it will be effected to be guilty the accused petitioner for the purpose of the case. And I am going to discuss about murder case with circumstantial evidence. And circumstantial evidence is very important part and how to use or to provide it before honorable court, and the honorable court can decide with the circumstantial evidence about murder case being guilty the accused for the purpose of the allegations which is alleged or which is bringing allegations by the prosecution, because what happened or act done by the any person and the person is connected for doing act this work or offense and he was at the present of offense he is the guilty or the accused for the case. Number one, being guilty, the accused petitioner of the case have to identify eyewitness. An eyewitness or a direct evidence. Eyewitness is the direct evidence and it is very effective to get the benefit of the prosecutions, and it will be it is very strong evidence. And being guilty the accused, thank you Subrata Haldar, thank you very much. And I am going to discuss with example. A killed his wife because arising of thought illicit relations with another person, and this word is known to the deceased husband and it is very painful for a husband, and he always try to hold or catch the person who are engaged with his wife as a illicit relationship. Illicit relationship is very disease for the society. Always we are avoiding from this fact because for the purpose of the case doing act by the person who is the accused of the case. The accused seen directly his with another person or stay with another person. This is very painful and very harmful for mind of any person because reality is very painful, and he protect to try to control on self, but there is not possible for any person, and he killed his wife because his wife, she always continues the illicit relations with the another person, and as a result of this or for that broken the family happiness, and they are unhappy for that because the court can decide that the person is connected for doing act and submitted eyewitness before the court, and with evidence can convict the accused under section 302 because ingredients of this section it will be identified, and it's very necessary to get. Thank you, Parvez, and connect it with me, and Parvez always support me, and my dear younger brothers, and we are strong family. Thank you very much. Actually, except eyewitness being guilty, the accused, another witness, surrounding witness means circumstantial evidence provide that, and having chance to be guilty, the accused for the purpose of the allegations always never recovery eyewitness or not present before court of the eyewitness of the case, and when the accused petitioner doing act, he always finish the witness because he will be guilty for the purpose, and he has intention to finish or destroy the witness, which is very essential for the purpose of the case. And the accused petitioner destroyed the eyewitness, and surrounding or circumstantial witness provide that, and there is chance to identify being guilty the allegations which is arising by the prosecutions against the accused petitioner, because under section 302 of the penal code it will be provided that with relevant documents there is no options to submit the eyewitness, another options to submit circumstantial evidence. Santosh Chandra Roy, thank you very much. Circumstantial evidence means actually A is guilty or accused, but there is no eyewitness, and recovery the knife and blood related cloth and forensic report, those are identified with analysis. It will be provided before the court, and that is circumstantial evidence, because direct evidence means eyewitness, one person or any person can see that when the doing the offense by the accused, if none can see the offense, then collect circumstantial evidence. Thank you, Santosh. Thank you very much. Circumstantial evidence will be preferred before the court with recovery documents. Alamat Uddar Section 27 Evidence Act and Burden of Proof Section 106 of the Evidence Act 1872. Prosecution has liability to prove submit the relevant documents, means there is no chance to submit eyewitness, and except eyewitness have to maintain or to enjoy the punishment against the accused petitioners by the passing by the honorable court, have to identify the guilty against the accused petitioners and mentions with circumstantial evidence, actually recover NIF, recover blood-related cloth, and the person who is accused running from the place of occurrence, same time it will be identified that because started investigations by the investigate officer or IO, and to try to collect circumstance evidence, and the accused is absconding from the beginning of the offense because creations doubt, absence of the accused petitioners, and accused petitioners is the killer or guilty or criminal of the case, and it is very too clear that the accused or absconding person is the accused of the case. I hope that my lecture will be clear, or I try to explain easy, and for law students or lawyers who are practicing regular in lower court or high court divisions, because to know about murder case or criminal case have to know circumstantial evidence, about circumstantial evidence which is affected to change or to decide about convictions, and convictions which is relevant or not depends on circumstantial evidence except eyewitness, because when the offense there is no eyewitness, none can see the offense, or none can present at the place of offense. According to circumstantial evidence, there is the more options be guilty by the court to the accused petitioner, because always never recovered direct evidence on the basis of the circumstance evidence. The accused will be convicted by the or submitting of circumstantial evidence before honorable court. But to be clear or mentions that and produce related of the circumstantial evidence which is very essential and produced before the court, otherwise never possible to identify the guilty person about the arise allegations of the case, because allegations must be identified specific and submitting relevant documents collected or recovery NIF or blood related cloth or any other subject which is very important role, and the person is the connected for the purpose of the case and finding the circumstantial evidence which recovery documents is relevant and allegations is relevant against the accused petitioners of the case, and burden of proof on prosecutions under sections on behalf of the prosecution under section 106 of Evidence Act, section 27 of Evidence Act, and there are some options to collect another evidence which is submitted before honorable court, that is circumstantial evidence, because except eyewitness convicted the accused petitioner or accused by the honorable court, because circumstantial evidence with recovery documents submitted before the court. I hope that my lecture will be helpful for you, and thank you very much, and thank you to everyone who are joining the live sessions or supporting me. And if you have any questions written in comments, your thought, I will solve your questions by my lecture, because section 302 grievous hurt identified section 320 of penal code and 8 elements of grievous hurt, because murder case is grievous hurt under section 320 of penal code, except eyewitness there is no chance be acquitted of the accused. Circumstantial evidence provide that with recovery document, forensic report, MC, extrajudicial confessions, those are relevant for the purpose of the allegations of the case against the accused, and there is no options to deny the allegations which is bringing allegation against the accused petitioners, because there is the important score, because none options to avoid the allegations which is arising against him or she who is accused for the purpose of the case, because being guilty the person who is connecting with the case of circumstantial evidence, the court can decide that the person is accused and guilty and convicted by the passing order which is decided by the honorable court, and this is relevant and it is enforcement against it. After convicting the accused has options to do jail appeal of for jail applications before High Court divisions. Then High Court divisions can decide the convictions of trial court which relevant or not, analyzes the circumstantial evidence or essential evidence which is submitted before court. So there is no chance the person as a advocate appointed by the client, there is no options to submit or to submit before the court because allegations against me is not relevant. There is no eyewitness of the case. No chance to say about this because except eyewitness, another witness, circumstantial evidence which is submitted with recovery documents, this is relevant. On the basis of the circumstantial evidence, the court convicted the accused under section 302 or another section which is related for the purpose of the case. Thank you very much, everybody watching and listening me, and to stay with me. This is the great achievement in my life, and I hope that and every viewers joining the live sessions and watching and listening me, and sometimes comment in comment box, and I try to solve the questions by my speech. And I hope that under section 302 of Penal Code, allegations against the accused petitioners which is relevant, there is no chance only for submitted of circumstantial evidence, because circumstantial evidence is relevant with documentary recovery document by the investigation officer or extrajudicial confessions. Prefer that the circumstantial evidence is relevant, and for the purpose of the circumstantial evidence, court pass the order and convict the accused petitioner against the accused, or accused is connected with the case and there is more options because recovery needs recovery blood related cloth, and at the place of offense there are some instrument recovered by investigation officer, and I hope that my lecture will be helpful for you for your career, who are deciding being trial lawyer in future and who are regular practicing in lower court or high court divisions in the side of criminal. Thank you very much and joining the sessions and to continue to stay with me and listening and watching me. This is the great achievement for my life in my life. And I hope that next time with another case and it will be helpful for you. And living in the society peaceful, you have to know about criminal and civil law, because every person who are citizen of Bangladesh below 18 years or plus 18 years, 18 plus, have to know law which is essential for surviving in the society. Without knowledge of law, you have done act, there is no chance to deny your allegations against you, because which is submitted with circumstantial evidence and recover document, and then circumstantial evidence is relevant and allegations of the case it will be relevant or is relevant and convicted the accused by the honorable court. And thank you very much, Santosh. Thank you joining the live sessions and stay with me. Good night. Namaskar.